In March 1957, a Manhattan court kept Andrew Carnegie's fortune under trust control and reduced Margaret Carnegie Miller to a secondary interested party, cut off from real access, while the record called it final and no one objected. The victim is Margaret Carnegie Miller, Andrew Carnegie's only child, raised inside the Fifth Avenue house that carried his name, and later treated by the public as the natural custodian of whatever remained of that legacy. The act of injustice is direct. On March 14, 1957, in New York County Surrogate's Court, a judicial order confirmed the execution of the will and the continuing administration of the trust, authorizing the estate's control to proceed while she was functionally sidelined, present in name, diminished in standing, and denied any practical share of influence over what the court treated as settled. The beneficiaries were not strangers in an alley. They were the estate's institutional perimeter, trustees and counsel empowered by the court to keep the machine running uninterrupted. A courtroom does not need to raise its voice to humiliate someone. It only needs language that sounds neutral. Interested party can read like inclusion. In practice, it can be a demotion. You are acknowledged, then managed, cited, then constrained. The record does not have to accuse you. It only has to place you lower in the hierarchy of attention, lower access, fewer answers, less standing to demand what you cannot see. Humiliation in this form is not an insult. It is a classification that follows you through every subsequent page. And the mansion in this story is not scenery. It is the image the law knows how to protect. The Andrew Carnegie Mansion, 64 rooms built from 1899 to 1902, was designed to look like settled respectability, not conquest. Brick, symmetry, permanence. Even after the family era ended, the building's afterlife would be managed with the same steadiness. It was leased for institutional use and later transferred to the Smithsonian, preserved as a public-facing monument long after the private household had vanished. In this case, that contrast is the point. A structure remains intact while a living heir becomes procedural. The mansion is protected as a legacy object. The person is handled as an administrative variable. This is the method we are examining, a perfect legal form that can produce a perfect personal diminishment. It is why the opening line of this case lands with such cold finality. The will is valid. The outcome is final. It sounds like closure. It also functions as a barrier. It ends the conversation before the person most affected has practical access to the material that would make a conversation possible. When law becomes a lever, the first move is often informational. Who gets to see, who gets to ask, who gets to cross-examine the archive rather than accept it. Place this in its moment. 1957 is remembered for public events that could not be hidden. The Cold War sharpening into spectacle, and later that year, the shock of Sputnik crossing the sky and changing how Americans thought about technology and national power. The country was also negotiating its self-image on paper. On September 9, 1957, President Eisenhower signed the Civil Rights Act of 1957, a cautious but historic admission that legality and dignity were not the same promise. That tension mattered beyond politics. It mattered inside institutions that spoke in calm voices and insisted they were only following procedure, because procedure is where reputations are stabilized, and reputation in this century is not decoration, it is a form of property. The Carnegie name intensifies the contradiction. Andrew Carnegie's public narrative is philanthropy and progress. Institutions built to outlast him, a fortune framed as responsibility. But private wealth does not run on narrative. It runs on governance. Trusts, fiduciaries, counsel, approvals, layers that can be presented as protection while functioning as containment. In that system, the heir is not always treated as an owner. The heir can be treated as a risk, something to be kept calm, kept polite, kept proper, and, above all, kept outside the rooms where certainty is manufactured. So when the court's language reduces an heir to a secondary presence, it does not need theatrics to achieve degradation. It only needs procedure, a hearing calendar, a clerk's stamp, a file that moves forward while the person it names is left waiting outside the room, where decisions are translated into permanence. The law is not breaking anything. It is using everything, every definition, every threshold, every standard of deference to produce a result that feels inevitable the moment it is typed. If you want continued access to the closed doors, the citations, and the paper trail, subscribe to Beyond the Golden Halls and leave a like as a matter of record. What we have at the start is not a melodrama and not a scandal anyone would print on the front page. It is something colder, an institutional decision that treats exclusion as administration and administration as legitimacy. The mansion remains intact. The legacy remains polished. And on March 14, 1957, the first proof of humiliation is not shouted. It is filed. A single courthouse date, a single line in a court record, and a door that closes with the softest sound, paper returning to a folder. On April 3, 1957, the story stops being a courtroom scene and becomes what it always was underneath. A file that keeps moving even after the public has been told there is nothing left to see. You do not find that kind of movement in headlines. You find it where movement is reduced to a line, an entry that looks too small to matter until you understand what it controls. An index, a docket list, a clerk's register that does not explain, does not argue, does not persuade. It only records that something was filed, something was assigned, something was carried forward. That is why it survives. It does not sound like a controversy. It sounds like routine. The trace appears in the New York County Surrogate's Court archive, the way most decisive things appear when they are meant to pass without public attention, as administrative language stripped of drama. A case number, a date, a short description that assumes you already belong inside the process. It reads like a note to insiders, not an explanation to the world. Petition, accounting, decree. And then the words that tighten the circle. Without announcing it, beneficial interest, consent, waiver, the kind of terms that can extinguish a person's leverage without ever using the word deny. What makes the April 3 entry matter is not that it exists. What makes it matter is that it exists at all after the public version of the Carnegie legacy has already been packaged as settled, dignified, concluded. In the official tone, the mansion endures, the institutions endure, the name endures, and whatever was private is assumed to have been resolved quietly, decades earlier, in a way that required no further attention. That is how the public likes inheritance to behave, as a clean handoff, a dignified ending. But the docket index does not care what the public likes. It only shows that in 1957 there was still active process, still a living mechanism of control being maintained, still formal steps being taken inside the court that supposedly had nothing left to do. That single line is enough to prove a second truth beneath. The first, if the outcome was final on March 14, 1957, then what exactly required formal handling on April 3? If nothing was in dispute, why does a petition exist? If there is no meaningful participation from the heir, why do consent and waiver appear as categories at all? An archive entry does not accuse anyone, but it creates a problem that the public story cannot absorb. It shows post-1950 activity tied to the estate's control, an active step that the popular narrative never mentions. Because it has no place for it. The index entry is small because it is designed to be small. It is the difference between an event and a procedure. Events attract witnesses. Procedures attract only the people who have standing to ask the clerk for the file and the patience to keep asking when the answer is delayed. Most people never do. They assume that whatever matters would be obvious, and the system depends on that assumption. This is where power becomes visible, not as a villain with a face, but as access that can be granted, restricted, reassigned, and quietly normalized. In a court archive, access is not a philosophical idea. It is a decision a human being makes behind a counter. A file can be not available. A box can be off-site. A record can be sealed. A request can be treated as premature or improper. None of those responses need to be hostile to accomplish the same result. Delay the person who does not belong to the circle and accelerate the people who do. In this case, the circle is not mysterious, it is institutional. Trustees and estate council have the vocabulary, the authority, and the continuity. They know which index book to consult, which clerk to speak to, which petition format to file, which accounting language to use. They do not need to explain themselves to the press because the press rarely sees the mechanics, and the heir, Margaret Carnegie Miller, can be present in name and still be practically excluded in function. That is what secondary interested party does when it leaves the courtroom and enters administration. It follows the person into every subsequent interaction with the record. An April 3rd docket line does not tell you the content of the petition, the details of the accounting, or the exact wording of any waiver. That is not its job. Its job is to confirm that the mechanism existed and that it continued. It confirms a stage after the supposed end. It confirms that the estate's governance did not simply rest on the dignity of a will, but on continuing court-facing management, steps that required documentation and therefore left a trace. And that trace has an implication that is difficult to say plainly without overstating it. If a petition and accounting were processed in 1957, then someone was still shaping what could be asked, what could be challenged, and what could be treated as already agreed. Inheritance is often described as transfer. In practice, in trust structures, it is often filtration. Who gets information first? Who gets it late? Who gets it in full? Who gets a summary? Who gets a choice? Who gets a form to sign? This is the part the public never sees because the public is trained to look for spectacle. But humiliation in these cases is rarely a scene. It is a system. You take a person attached to the name, you reduce their position in the record, and then you move the estate forward through steps that make the reduced position permanent. The person becomes a category. The category becomes a constraint. The constraint becomes the new normal, and because it is done through ordinary words, accounting, consent, waiver, it can pass as responsible management, even when it functions as containment. The April 3rd trace also clarifies something else. There were people with meaningful access at a moment when the heir's access was already compromised. The file did not produce itself. Someone requested action, someone filed, someone spoke to the clerk, someone benefited from the court, treating those filings as legitimate and routine. That someone does not have to be a single individual to be real. In institutional systems, someone is often a role. Trustees, fiduciaries, counsel, administrators, a structure that keeps its own momentum. If you want to understand why the injustice can remain intact without public outrage, you start here. At the moment, the record reveals a continuation that the public was never invited to notice, not because it proves the whole mechanism, but because it proves the existence of a path, a bureaucratic corridor where decisions can be made without being staged as decisions. There is a reason the public story prefers closure. Closure protects reputation. It protects the idea that great legacies are tidy and morally clean. It protects the institution that inherits the building, the name, the prestige, and the narrative of orderly transition. But a docket index is indifferent to reputation. It is the kind of object that only tells the truth it is built to tell, that something happened in the system, on a date, under authority, in a way that was meant to be processed rather than debated. And that is what April 3rd, 1957 is, a processed step, a line that should not be necessary if everything truly ended when the court said it ended. A small administrative footprint that proves the estate's control did not simply stand on principle. It required maintenance. It required paperwork. It required that someone, somewhere, was still exercising power through the court's machinery. If a case appears only as a line in an index, what else stays outside the official story? The next question is not abstract, and it is not rhetorical. The next question is practical. What exactly did that petition or accounting authorize, restrict, or seal? And who, on paper, was made to consent to it? Because once a waiver is filed, the record stops asking whether exclusion is fair. It starts treating exclusion as agreed. In the archive, the trace is not dramatic. It is a thin strip of microfilm, a faint line of typed text, a clerk's notation that fits inside a ledger margin, and yet it sits there like a locked door that has been painted to look like a wall. To understand why that April 3rd, 1957 line matters, you have to understand what the year itself did to people like Margaret Carnegie Miller, and what it threatened to do to everyone who depended on the Carnegie name remaining uncontested. 1957 was not a quiet year in the way a museum plaque suggests. It was quiet in the way institutions prefer: public calm, private movement. The country was post-war but not settled. The economy was strong on the surface, brittle underneath, and the elite class that managed legacies understood something most outsiders never learn until it is too late. Reputations are not defended with speeches. They are defended with procedure. That matters because a trust is not only a legal instrument, it is a reputation instrument. It takes property, removes it from ordinary personal control, and places it inside an administrative language that sounds responsible even when it is punishing. Preservation, stewardship, fiduciary duty. These words do not merely describe ethics. They create a social shield. If you fight them publicly, you are not merely disputing money, you are disputing care. And if the name attached to the money is Andrew Carnegie, the dispute becomes something even more dangerous, an implied accusation that the benefactor's legacy was not as clean, stable, or well-governed as the public has been taught to believe. For Margaret Carnegie Miller, the danger in 1957 was not theoretical. It was structural. She had a name that the public associated with continuity, dignity, and philanthropic permanence, but she was operating inside a system that treated her as a procedural subordinate. Once a court record places you in a reduced category, you do not simply lose a hearing, you lose a posture, you lose the ordinary leverage that forces institutions to answer. You become the person who must request access, justify your interest, accept delays, accept summaries, accept that someone else is managing what you are allegedly connected to. And in a trust-controlled estate, the real power is not the final judgment that everyone quotes. It is the stream of administrative actions that follow: accountings, petitions, approvals, waivers. Each one small enough to avoid attention, each one consequential enough to shape reality. In that era, the risk of letting any of this become visible was compounded by the way public attention worked. The mid-century press did not need to understand trust mechanics to cause damage. It only needed a moral hook. Carnegie heir fights estate, family dispute, philanthropic legacy challenged. That is the kind of framing that takes a private legal dispute and converts it into a reputational event. And reputational events had direct consequences for institutions. Board relationships, donor confidence, museum governance, social alliances, even the quiet credibility that keeps powerful people powerful without needing to announce it. That is why 1957 is dangerous, not only for the elite, but for the person on the wrong side of the elite's methods. If Margaret pushed too hard, too publicly, she risked being cast not as an heir seeking clarity, but as a problem, an inconvenience to good governance, an obstacle to orderly administration, a destabilizing figure around a celebrated legacy. The system could tolerate private complaint. It could tolerate disagreement inside the file. What it could not tolerate was disorder in public language, and the system had tools that were perfectly designed to prevent public language from ever forming. In surrogate's court practice, you do not always defeat a person by proving them wrong. You defeat them by controlling the corridor they must walk. What gets filed, what gets scheduled, what gets sealed, what gets treated as consented to, what becomes final. A docket line is not just a note. It is the visible edge of a process designed to compress conflict into record-keeping and record-keeping into inevitability. In this period, 1956 through 1958, older estates were not as finished as public mythology suggested. Trust structures can keep assets controlled for decades. Clauses can be reinterpreted. Residual interests can be recalculated. Accountings can be demanded or strategically offered. The act of producing an accounting is not neutral. It is a moment of power. Whoever controls the accounting controls the narrative of what exists, what it produced, what it cost, and what remains. And whoever controls the timing controls the other party's options. A late accounting can function like a locked door. A narrow accounting can function like a blindfold. This is where the April 3rd trace becomes more than a curiosity. It shows the mechanism alive at a moment when the public story prefers closure. It indicates that something inside the Carnegie legal structure still required court-visible maintenance, a petition, an accounting, a decree, words that are synonymous with continuing control. And continuing control is never just about money. It is about who can speak with authority about the estate, who can question it without being dismissed, and who can compel answers rather than request them. The elite preference in those years was not to fight in public. It was to resolve in the room. That phrase, sometimes spoken, often unspoken, captures the entire strategy. Do not generate a trial. Do not generate depositions that leak. Do not create a record that invites reporters to read. Do not create testimony that can be quoted. Instead, resolve it through filings that sound administrative and final. If you must correct something, correct it in a decree. If you must obtain cooperation, obtain it through a waiver. If you must remove a risk, remove it through procedure. The power move is subtle but concrete. The dispute is reassigned from the public arena to the clerk's domain. It is transformed from conflict into paperwork. And once it is paperwork, it becomes nearly invisible to everyone who does not already know where to look. That is why institutions love it. It is why legacies survive scandals that never become scandals. The public sees the building. The insiders see the docket. The consequence for the victim is equally concrete. The moment conflict is compressed into procedure, the person without institutional standing loses oxygen. They lose time, they lose information, they lose the ability to frame the story as a moral issue rather than an administrative nuisance. In the worst form, they lose the ability to contest at all, because every subsequent step is presented as already agreed, already settled, already waived. The law does not need to silence you by command. It can silence you by creating a sequence in which your speech arrives after the door has already been closed. By 1957, the Carnegie name was not just personal, it was infrastructural, tied to institutions, to boards, to public trust. That is what makes philanthropy such a powerful shield. It converts wealth into moral capital. And moral capital is protected differently than ordinary capital. Ordinary capital can tolerate a fight. It can even profit from publicity. Moral capital cannot. If the public begins to associate the name with internal conflict, exclusion, humiliation, or manipulation, the aura dulls. The building becomes less innocent. The foundations look less inevitable. The legacy starts to look like management rather than destiny. So the system's preferred solution in 1957 was not to win loudly, it was to conclude quietly. Legal, silent, final. The very words the opening line gives you are the words the era rewarded. The will is valid, the outcome is final. That is not simply a statement. It is a strategy aimed at preventing the next sentence from ever being spoken in public. The sentence that begins, "Then why is there still an accounting?" Because an accounting reopens what the public thinks is closed. It suggests unfinished governance. It suggests continuing discretion. It suggests that someone is still deciding what counts as legitimate interest, what counts as consent, what counts as participation. And if those decisions are being made while the heir is being treated as secondary, the danger is not only that the heir is harmed, the danger is that the harm becomes legible, and once it is legible, it becomes a story. In 1957, stories about elite governance were not mere gossip. They had consequences. They could affect alliances. They could unsettle boards. They could trigger scrutiny. They could invite other interested parties to ask questions. They could encourage other heirs, other beneficiaries, other sidelined people to test their own boundaries. One visible crack is never just one crack in a structure like this. It is an invitation. That is why the file had to keep moving without becoming visible. That is why the decisive steps had to be made to look like routine. And that is why the trace we found is so coldly important. It is proof that the legacy was being actively maintained through court-facing procedure at the exact moment the public was meant to believe nothing remained to contest. What comes next is not a grand reveal. It is the closer work, identifying what, in that post-March corridor, was treated as agreement, and whether the record shows someone being asked to surrender leverage without being given real access to what they were surrendering. Because on April 3, 1957, the archive gives us only a thin thing, an index entry, a case identifier, and a few words that do not belong in a story that is supposedly over. And the next step is to pull on those words until they stop being words and become acts, until consent becomes a signature, waiver becomes a surrender, and accounting becomes the controlled narrative of what the heir was not allowed to command. The last image of this block is not a mansion. It is smaller, harder, and more telling. A clerk's ledger on a microfilm reader, the April 3rd line glowing faintly on the screen, and the quiet question it refuses to answer. What exactly was being handled after the court said it was final? January 9th, 1957 is not remembered because it was public. It is remembered in the surviving logic of the record because it is the moment the people managing the Carnegie estate stopped treating the situation as a family disturbance and began treating it as an administrative risk that required intervention. The meeting did not need a courtroom to exercise power. It needed an office, a table, and the kind of participants who do not introduce themselves in public notices because their authority is assumed inside the file. Trustees, counsel, a representative tied to the property's institutional future, people who could speak in the language of duty while deciding outcomes that would never be described as decisions. By the time they convened, the problem was already defined in institutional terms. Not what is fair to the heir, but what is stable for the estate. Not what does Margaret Carnegie Miller have a right to see, but what must be clarified so the administration can proceed without interruption. The vocabulary tells you what they believed they were protecting, and who in that protection could be treated as secondary. This is where the character of elite governance reveals itself. It rarely starts with a dramatic confrontation. It starts with a shift in posture. For a while, the system tolerates noise. It answers some requests. It delays others. It manages irritation with politeness. It keeps the conflict inside a narrow channel so it doesn't become a story. But there is always a threshold where tolerance becomes strategy. January 9 is the threshold. The decision is not to fight louder. The decision is to end the possibility of a fight by converting a human dispute into a procedural matter. In practice, that conversion happens through clean words that can do hard work without sounding hard. Clarify, regularize, confirm, protect the house. These words do not describe neutral housekeeping. They describe a transfer of leverage. To clarify is to decide what counts as legitimate. To regularize is to declare what has been irregular. Often the heir's questions, the heir's discomfort, the heir's refusal to accept a reduced role. To confirm is to freeze a contested reality into an official one. And protect the house is never merely about brick. It is about the public surface of the legacy, the mansion intact, the name intact, the governance unquestioned. The choice to intervene formally also reveals what they feared most. Inheritance disputes can exist quietly for years. Trustees can manage discomfort. Council can draft careful letters. But the moment a dispute threatens to reopen old governance, threatens to force the estate to show its internal workings, to explain why an heir is being treated as a lesser party, the risk becomes systemic. Once questions enter the court in a way that demands answers, the estate loses control of timing. Once timing is lost, narrative control follows. So in that office on January 9th, the power was exercised in a particular way, through the decision to seek finality by decree rather than by persuasion. That is the key. A decree does not need the heir to be convinced. It needs the heir to be categorized. It needs the court to recognize the estate's posture as orderly and the heir's posture as disruptive, or at least non-essential. A decree moves the estate forward. It compresses disagreement into a phrase: valid, final, authorized. It turns future objections into something that must climb uphill against an already closed outcome. This is the part people miss when they imagine courts as arenas where truth is argued openly. In trust governance, the most decisive argument is often made before anyone speaks in court. It is made by choosing the frame. If the issue is framed as administrative regularization, then the court is invited to treat it as maintenance. If it is framed as protection of the estate, then the court is invited to treat it as duty. If it is framed as confirmation, then the court is invited to treat any challenge as belated. And once that frame is chosen, the heir's position changes even if nothing about the heir has changed. Margaret Carnegie Miller does not need to be declared unworthy to be diminished. She only needs to be repositioned as someone whose presence is acknowledged, but whose participation is not required for the machinery to operate. That is exactly what secondary interested party becomes outside the courtroom, the justification for moving without her while still claiming she is included. The decision to intervene also reassigns where power lives. When a matter is family, there are social limits. There is embarrassment, there are relationships, there is the possibility that someone might protest out of pride, loyalty, or fear of appearing cruel. But when a matter is administration, those limits weaken. Administration is allowed to be cold. It is allowed to reduce people to roles. It is allowed to call exclusion order. It is allowed to treat a person's discomfort as immaterial if the file moves cleanly. That shift is not accidental. It is the reason intervention happens behind closed doors. It is why trustees and counsel meet privately before they appear publicly. The goal is to arrive at the court with the dispute already translated into language the court can accept without hesitation. The goal is to remove moral ambiguity from the record by replacing it with institutional certainty. You can see the logic in the sequence that follows from this decision. A formal intervention in January makes March possible. It sets the tone. It establishes the posture. It prepares the court to treat finality as a virtue rather than a question. It also prepares the estate to treat post-decree procedure as routine. Once the decree exists, subsequent steps, accountings, petitions, waivers, can be processed under the shelter of already decided. And that is the real consequence of January 9th. Not that a single decision was made, but that a pathway was chosen, a pathway that would carry the estate into surrogate's court with a prepared conclusion, and carry the heir out of meaningful participation while still being referenced in the paperwork. The dispute stops being something that could be negotiated through pressure, relationships, or public scrutiny. It becomes something that can be managed through filings. There is another consequence that matters just as much. The decision narrows the number of people who will ever be able to see the full picture. Once counsel and trustees decide the matter will be finalized, the flow of information becomes more disciplined, drafts are controlled, records are summarized, conversations become memorialized only in ways that protect the estate. Access becomes something granted, not assumed. Even language changes. Instead of discussing what someone deserves, they discuss what someone is entitled to under the instrument. Instead of discussing what is right, they discuss what is authorized. The moral vocabulary is replaced by the procedural one, because the procedural one wins. This is also why the intervention is not neutral for the heir. It is dangerous. It changes the terrain under her feet while she is still standing on it. A person can contest a family. A person can appeal to relationships. But contesting an administrative posture is different. Administration does not feel shame. Administration does not respond to indignation. Administration responds to compliance and deadlines, and it punishes the lack of both by moving forward without you. And by moving forward, it creates a new truth. Not the truth of what happened, but the truth of what is now recorded as settled. That is what decrees do. They convert a choice into an outcome, and then they convert the outcome into a reference point for every future step. Once the outcome is treated as final, anyone who asks questions afterward can be described as reopening what was already closed. The burden shifts. The heir is no longer a participant seeking clarity. The heir is an irritant, resisting closure. What makes this especially cold is that the language remains polite. No one needs to insult her. No one needs to declare her unfit. The system can be perfectly courteous while reducing her power to almost nothing. That is why institutional humiliation is so effective. It allows everyone involved to believe they behaved properly. They followed procedure. They protected the estate. They clarified governance. And the person harmed is left with the most isolating kind of injury, one that cannot be easily named without sounding unreasonable to outsiders. Because how do you explain that you were harmed by the word confirm? How do you explain that regularize meant you were cut out? How do you explain that protect the house meant the living heir became less important than the building's uninterrupted calm? January 9th is the moment they decided they would not risk that explanation ever reaching the public. They would not risk depositions. They would not risk a drawn-out fight. They would not risk a narrative that could attach to the Carnegie name. They chose the path that produces the cleanest surface, a decree that sounds final, and a continuing administration that sounds routine. And once you understand that, the April 3rd trace stops being mysterious and starts being inevitable. If trustees and council decided in January that the goal was to finalize and reduce risk, then the docket line in April is not an afterthought. It is part of the continuation, the maintenance work that happens after finality is declared. It is what you do when you have secured the court's posture and now need to keep the machine moving, accountings processed, interests defined, consents obtained, waivers filed, loose ends tied in language that does not invite inspection. The unsettling part is what remains unknown inside the decision itself. We do not have the meeting transcript. We do not have the full list of who spoke, but we have the kind of evidence that matters in institutional stories, the sequence of outcomes that follows, a private intervention, a public finality, a continuing procedural trace, a living heir reduced in the record. The last image here is simple and concrete. A January 9th calendar page on a council's desk, a typed memorandum header with the word re-estate administration, and 3 clean verbs underlined in pencil: clarify, confirm, protect, while the file that will soon be called final is quietly prepared to keep moving. February 22nd, 1957 is where the case stops being argued in principle and starts being engineered in paper. If January 9th was the private decision to intervene, February 22 is the day the intervention becomes real, through preparation, attachments, and the quiet reconfiguration of what the record will later call participation. In a trust dispute, the most decisive change is rarely a shouted confrontation. It is the moment the documents are assembled in a way that makes contestation practically impossible. That is what preparation means here, not clerical tidying, not routine filing. Preparation as a form of power, the deliberate shaping of what will be visible to the court, what will be legible to the heir, and what will be treated as already settled by the time anyone is allowed to object. On February 22nd, the key object is an accounting, not because an accounting is inherently suspicious, but because it is the easiest place to alter reality without looking like you altered anything. An accounting can be updated, it can be adjusted, it can be clarified, it can be presented as a neutral summary of facts. But in practice, an accounting is also a narrative. It defines what counts as an asset, what counts as a distribution, what counts as a duty, what counts as consent, and most crucially, what counts as an interest worth hearing. When you change the accounting, you can change the heir's position without ever issuing a declaration that sounds hostile. You do it by moving the heir's interest from the center to the margin. You do it by refining phrases until they become barriers. Remote interest, non-controlling beneficiary, no standing absent leave. Each term sounds technical. Each term changes what a person can do. The alteration is not merely semantic, it is practical. If Margaret Carnegie Miller is recorded as a beneficiary without controlling interest, then she is transformed from someone who can demand information into someone who can request it. If she is treated as having no standing absent leave of court, then every attempt to intervene becomes an uphill petition, not a right. If her interest is described as remote, then the moral intuition the public would have, she is the heir, is overwritten by the procedural intuition the court is trained to respect. She is not central to the administration. This is how an heir loses the only weapon that matters in an institutional fight: informed participation. Because participation without information is theatre. It allows the record to say you were included, while the outcome is built elsewhere. The second object on February 22nd is the collection of consents. Consent in these files is not always a conversation. It is a page. It is a signature line. It is often obtained through counsel-to-counsel contact, not person-to-person explanation. The language is designed to be easy to sign and hard to reverse. If a consent is filed, later objections can be dismissed as inconsistent. Belated, disruptive. The system prefers consents because they convert power into inevitability. But consents also have another function. They allow the estate to say, in a court-facing posture, that no one is being overridden. Everyone agreed, everyone participated, everyone understood. That is the public-facing morality of administration. It is why February 22nd matters, because it is the day the file begins to assemble the appearance of agreement, even if the underlying reality is exclusion. Then there are the attachments. This is the part that never shows up in a simplified narrative, the sealed wing of the file. In a contested estate, the annexes are where the real decisions hide under the disguise of support material. Inventories, correspondence, trustees' memoranda, council opinions, internal notes about governance, references to prior understandings that never appear in public summaries. These are not always dramatic documents. Often they are dull, which is precisely why they work. Dullness keeps outsiders away. On February 22nd, those annexes are treated not as optional background, but as something that must be controlled, restricted, sealed, omitted from circulation. When an annex is sealed, it is not merely hidden from the press. It is functionally removed from the heir's practical reach. The file can then operate in two layers at once: a visible layer that appears clean and administrative, and a hidden layer that contains the rationale, the internal debate, the private fears, the strategic framing. That restriction is an action of power. It is not passive. Someone decides what becomes an attachment. Someone decides what becomes a sealed attachment. Someone decides what is provided as summary instead of full copy. Someone decides, in effect, who will be able to argue with knowledge and who will be forced to argue in the dark. And arguing in the dark is not argument at all. It is desperation made to look unreasonable. The alteration also touches the way access is handled. In ordinary life, if you are the person named in a matter, you assume you will be informed. In this world, access is not assumed, it is managed. A folder can be kept for counsel. A document can be available for inspection under conditions that make inspection meaningless. Limited time, no copying, no independent review, no opportunity to compare versions. The system does not need to bar you outright. It only needs to control the manner of your access so tightly that you cannot build a coherent challenge. This is how the estate protects the mansion by design. Not simply by owning it, but by designing a governance posture that makes the building's continuity the priority and the heir's voice the variable. The building is treated as an object of preservation. The heir is treated as an object of management. That is the moral inversion at the heart of this. The mansion is protected from disruption, and the heir is protected only from the ability to speak effectively. This is also where the earlier language, clarify, confirm, protect, turns into something you can measure. An accounting clarified the heir's interest into something remote. Consent language confirmed a posture the heir could not realistically challenge. Sealed annexes protected the estate from outside interpretation. Each clean verb maps to a hard result. And the timing matters. February 22nd sits close enough to March 14th that you can see the sequence. Prepare the record, collect. The consents, restrict the annexes, finalize the posture, then present finality as a virtue in court. The court does not see the preparation as strategy, it sees it as readiness. But readiness, in these cases, is often the weapon. If one side arrives with a clean package and the other side arrives asking for time to understand what has been packaged, the system reads the package as competence and the questions as delay. This is why the injustice persists, even when nothing illegal needs to happen. You do not need to fabricate a will. You do not need to forge a signature. You do not need to bribe a judge. You only need to structure the file so that the person most harmed cannot participate meaningfully before the system declares the matter resolved. Would you call it just when paper removes your presence before the discussion even begins? The most chilling aspect of February 22 is that it can be carried out without anyone raising their voice. The documents look orderly. The file looks complete. The council can speak in calm tones about duty. The trustees can claim they are acting responsibly, and the heir can be left with a formal status that sounds like inclusion while functioning as exclusion. This is not a tragedy of misunderstanding. It is a real alteration of the world through paperwork, an accounting adjusted, participation redefined, access restricted, attachments sealed. The consequence is not symbolic, it is practical. Margaret Carnegie Miller loses the ability to confront the record with knowledge, and once that is lost, the next courtroom statement, final, is no longer an argument. It is the closure of a door that was already built. The last image of this block is concrete because the mechanism is concrete. A thick file jacket stamped with a surrogate's court reference, a set of annexes tied with string and marked sealed, and a single page on top, an accounting summary, where a living heir's name appears only as a narrowed category, prepared to be treated as if it were always that way. By March 1957, the question was no longer whether the Carnegie legacy would be protected. The question was, who would be permitted to own the protection? Who would hold the keys, the files, the authority to decide what the mansion meant and what the heir was allowed to know about the machinery that kept it intact? A decree settles a dispute in public language. But the winners of a decree are not always the people the public would assume. The public hears final and imagines a family closure. The record hears final and opens a corridor of routine where power can be consolidated quietly, month after month, as if the consolidation were simply maintenance. That is what happens between March and June 1957. Control becomes habit, and habit becomes history. The practical beneficiary, first, is the institutional manager of the property and its legacy apparatus. The role that administers use of the building, access to its rooms, and, most importantly, access to the archive that turns a house into a public monument. Once governance is confirmed and contestation is minimized, the building stops being a family object and becomes a managed asset. Decisions about use are no longer framed as personal. They are framed as stewardship. That sounds noble. It is also powerful, because stewardship is the one word that allows custody to look moral while it becomes permanent. In this period, the mansion is not merely being preserved as architecture, it is being preserved as narrative. And narrative requires custody. Someone decides what is shown and what is stored. Someone decides what correspondence is treated as background and what is treated as dispositive. Someone decides what stories are told to visitors and what documents remain sealed in annexes. That person or that institution benefits in the most durable way by becoming the authorized voice of the legacy. Authorized voices do not have to argue. They simply speak, and the public accepts the speech as continuity, but the second beneficiary is quieter and more structurally important. Trustee and counsel themselves, not as individuals with dramatic motives, but as an internal model of governance that becomes stronger each time it succeeds. March 14, 1957, does not only establish an outcome, it establishes a precedent inside the estate's own administration. It demonstrates that when an heir becomes inconvenient, when questions become dangerous, governance can be regularized by decree, and the heir can be repositioned as remote without causing public scandal. That is an operational lesson, and operational lessons become policy. This is how control reproduces itself. The decree is not only a ruling, it is a signal to every future fiduciary. This is the method that works. Keep the conflict out of the press, translate moral tension into administrative language, collect consents, seal annexes, frame the intervention as preservation, then let routine finish what the courtroom began. The third beneficiary is the institution that inherits reputation, not necessarily in the sense of acquiring title overnight, but in the sense of acquiring insulation. A contested legacy is vulnerable to the simplest form of damage. Headlines that imply disorder. The decree reduces that risk. It creates an official closure that can be cited if anyone asks questions. The matter was resolved. The governance was confirmed. The court authorized continuation. Those phrases function like a firewall. They do not need to persuade skeptics. They only need to provide a respectable stopping point for anyone who does not have the appetite to dig deeper. And in the mid-century environment, most people did not dig deeper. Institutions relied on that. Newspapers were not structured to read trust accountings. Social circles were not structured to challenge fiduciary procedure. Donors and boards were not structured to invite controversy. They were structured to avoid it. A decree gives them a reason to avoid it with clean conscience. Meanwhile, the loss is not abstract. The loss is the heir's relevance. This is the most chilling exchange in these systems. The estate gains continuity while a person loses historical weight. Margaret Carnegie Miller is not erased in the literal sense. She is diminished in the way that matters most to power. Her name remains, but her position becomes procedural. The record can still cite her as an interested party, but the real decisions, use, access, interpretive authority reside elsewhere. Between March and June, that relocation of decision rights becomes visible in how routine operates. Routine fiduciary practices, approvals, record requests, correspondence control, meeting minutes, file custody, become the actual mechanism of exclusion. The court does not need to bar her from the archive every day. It only needs to validate a structure in which the archive is held by trustees and counsel, and the heir's access is mediated. Mediation is power. It means you never receive raw information. You receive processed information. You never engage the record directly. You engage someone's version of the record. This is why the winners are not always the owners in a common sense. The winners are the administrators of access. In trust governance, access is the currency that determines whether a person can threaten the system. And after March 1957, the currency is held outside the heir's hands. There is a measurable shift that follows. The mansion becomes protected by legal design, protected from being used as leverage, protected from becoming a site of dispute, protected from the public learning that the person closest in blood can be treated as secondary in function. The institutions around the property become protected from reputational spill. Trustees become protected from challenge by the posture of finality. Counsel becomes protected by the court's endorsement of the administrative frame. The only party not protected is the one the public assumes was the central figure of protection, the heir herself. Because what is she protected from in this structure? She is protected from disruption, yes, disruption meaning the ability to disrupt the file. She is protected from the burden of speaking, yes, speaking meaning forcing visibility. She is protected from being able to contest, because contestation is redefined as improper absent leave. The language of care becomes the instrument of removal. The benefit to the institutional manager of the property is therefore not merely operational, it is interpretive. Once you control the building's access and the archive's access, you control what the public thinks the building represents. And if the building is a Carnegie symbol, representation is not a small thing. It is reputational capital. It is the ability to present continuity while the record contains humiliation. The benefit to trustees and council is not merely that they won, it is that they demonstrated a method of winning that does not leave fingerprints in public life. It leaves only the cleanest fingerprint, a decree. Everything else becomes routine, and routine is the safest form of power because it can be mistaken for inevitability. If you look for the injustice here, do not look for a villain's smile. Look for the transfer of decision rights. Look for where the authority to decide moved. Look for who now sits between the heir and the record. Look for who can say no without saying no, by delaying, by summarizing, by sealing, by treating access as conditional. This is the trade the system made in 1957. It preserved the mansion and preserved the myth of orderly legacy, but it did so by lowering a living person's status inside the machinery that carries the name. The mansion remains intact in the public imagination. The heir becomes a technicality in the administrative reality, and the most durable benefit is this. Once the winners consolidate, control through fiduciary routine, the story becomes self-reinforcing. Future historians look at institutional continuity and assume it was natural. Visitors see the house and assume it was lovingly stewarded. Boards cite the legacy and assume it was orderly. The record, the one that shows humiliation, is buried in the annexes that never travel to the surface. The last image of this block is not a courtroom. It is an office routine made permanent. A stamped received mark dated June 6, 1957, on a fiduciary memorandum, a key tag for an archive room drawer, and a distribution list that does not include Margaret Carnegie Miller, while the mansion's public-facing quiet continues uninterrupted. By July 1957, the case no longer needed to win in court. It had already won where it mattered, in the routine. The decree had done its public work. The fiduciary model had done its administrative work. What remained was the quiet work that ensures an heir does not return as a problem, not by defeating her again, but by removing her from the circuit where participation becomes possible. This is the stage that rarely appears in legal summaries because it is not framed as a legal event. It is framed as housekeeping, an adjustment to the archive, an inventory update, a reclassification of rooms and materials, a restriction to protect property or privacy, civilized language for a single outcome. The person attached to the name is made less visible inside the machine that carries the name. The disappearance begins with the smallest thing that can still change reality: internal labeling, a folder name, a routing note, a distribution list for minutes. In July, those are the objects that determine who is treated as a participant and who is treated as an afterthought. It is not that Margaret Carnegie Miller's bloodline is erased. It cannot be. It is that her functional identity, the identity that gives a person the right to ask, to see, to object, is removed from the administrative. Grammar. In the earlier paperwork, she can still be cited because citations create the appearance of inclusion. But internal use is different. Internal use determines who receives copies, who is consulted, who is notified, who is allowed into the archive room without a request form. If her name disappears from internal use, the disappearance is practical. It means she is no longer expected to participate. Participation becomes something she must force, and forcing participation is exactly the posture the system can then label disruptive. This is how power makes itself durable. It does not merely say no. It creates conditions where the person stops being asked, stops being informed, stops being present in the flow. Then, when the person objects, the objection can be framed as an interruption rather than a right. The second disappearance is visual. Institutions curate continuity the way they curate art, by selecting what is shown and allowing everything else to fade into storage. July, official images of the legacy, photographs circulated in institutional contexts, promotional materials, internal displays, do not favor conflict. They favor architecture and patronage, the mansion, the benefactor, the polished surface of stewardship, images that suggest stability. A missing photograph is not proof by itself. But in a system like this, absence has a pattern. If the public-facing record favors the house and its aura and avoids the living heir in any context that could imply tension, the result is not neutral. It is reputational design. The legacy is presented as a seamless line from benefactor to institution, while the human being who would complicate that seam becomes less visible, not condemned, simply not circulated. And the third disappearance is physical, space. In wealthy households and institutionalized estates, space is policy. A room's function tells you who is expected to enter it. When a family archive room becomes storage, when an area becomes restricted, when a corridor is treated as off-limits except to staff, the change is not a minor operational detail. It is a shift in who is permitted to touch the record. This is where the mansion's protection becomes literal, not only protected by legal design, but protected by doors, by keys, by staff protocols, by the quiet authority of someone saying, that section is not accessible. You cannot argue with a locked room the way you can argue with a legal claim. A legal claim creates a debate. A locked room creates a delay. Delays exhaust people. Exhaustion is one of the oldest tools of institutional power. In July 1957, the family archive becomes an exception rather than a place. That is the point. Once access is exceptional, it is easily denied without looking cruel. Not today. Not without counsel present. Not without permission from the trustees. Each condition sounds reasonable. Together they form a barrier that functions like removal. The fourth disappearance is the most difficult to prove and the easiest to execute: omission. A letter that never enters the file. A memo that is not attached. A piece of correspondence that would clarify intention. What was meant, what was promised, what was feared, is treated as non-record. A non-record is not the same as destroyed, though destruction is always possible. Non-record can be achieved simply by routing. If counsel keeps it in a private file, it exists without being part of the official chain. If a trustee treats it as privileged, it can be withheld. If it is never logged, it is never discoverable by someone who is not already inside. This is how civilized erasure works. It does not always burn paper. It just declines to bless paper with official existence. The concrete action of power in this block is restriction. Materials are restricted. Rooms are restricted. Circulation is restricted. Names are restricted from the internal flow. The consequence is immediate and real. The heir no longer has a reliable path to informed participation. Even if she is still legally connected to the estate, she is administratively detached from the process that defines what the connection means. She is left outside the circuit where decisions and records travel. And because this happens after the decree, the system can insist there is nothing happening, nothing controversial, nothing to contest, just ongoing stewardship. That is the cruelty of the timing. Once finality is declared, every subsequent act of removal can be framed as routine maintenance. Anyone who complains looks like they are reopening settled ground. The record itself becomes a defense against the person it reduces. Notice what is missing when this kind of removal succeeds. There is no scandal, no dramatic confrontation, no public humiliation beyond the quiet humiliation already embedded in the classification. The victim does not need to be defeated again. She just needs to be absent from the circulation that creates authority. In an institutional legacy, authority is not only legal, it is archival. Whoever controls the archive controls what can be said with confidence. And in July 1957, control consolidates not by announcing itself, but by tightening the ordinary. This is also where the historical consequence becomes permanent. Once a person is removed from the circuit, future storytellers inherit a clean line. They inherit the mansion's continuity without inheriting the conflict that made continuity possible. They inherit curated photographs without the context of who was excluded. They inherit orderly inventories that do not show what was never logged. They inherit a record that can honestly say, "We have no documentation of that," because the documentation was never allowed to become official. You can see the method in the smallest details. A folder that once carried a personal name becomes a folder labeled General Administration. A room that once functioned as family papers becomes restricted storage. A photo set that once might have included the heir is edited to feature the building and the benefactor. A letter that would complicate the story is not located because it was never catalogued where an outsider could locate it. The injustice stays alive in those shifts. The mansion is preserved as a symbol of permanence. The heir is preserved only as a genealogical fact, not as an active voice in the record. The system does not deny her existence, it denies her circulation. And circulation is what makes a person matter inside governance. The last image of this block is stark because it is ordinary. A small brass key tagged Archive Restricted, a typed inventory sheet dated July 18, 1957, with a reclassified room listed as Storage, and a folder tab where a personal name has been replaced by a clean institutional label, while the door to the family papers closes without sound, and no one writes down that it happened. In August 1957, the record does something that records do when they have been forced to carry too much control in too few pages. It slips, not in a way the public would notice. In a way only a file notices, through a date that arrives out of sequence, a value that doesn't match prior language, a signature that appears late, as if time itself had been edited to keep the story smooth. The discrepancy is small on purpose. It has to be. Big contradictions trigger questions. Small contradictions trigger corrections. And corrections, in this kind of governance, are one of the cleanest ways to apply power while pretending you are simply maintaining order. The August trace appears as a supplemental entry, an addendum that does not announce itself as a reopening, but as a refinement. Sometimes it is stamped in a corner. Sometimes it is referenced by a line that looks like harmless bureaucracy. Corrected, amended, supplemental schedule. The language signals modesty. The effect is not modest, because in a case that was declared final, anything that requires supplementation is already a confession. Something needed adjustment after closure was proclaimed. What makes this detail dangerous is not that it proves a crime, it proves a method. If the estate's posture was that everything was resolved cleanly, then why do we see an administrative artifact that suggests retroactive alignment? Why does a notary timing feel off? Why does a signature appear in a place where an informed participant would have had to sign earlier, before the decree, before the sealing, before the reclassification of access? This is where the file becomes more honest than the narrative. A narrative can say final. A file cannot always maintain finality without small technical maneuvers, and technical maneuvers leave residue. One example of residue is timing that refuses to behave, an acknowledgement dated after the moment it's supposedly supported, a notarization that is placed after the operative event, an attachment dated outside the sequence of the main submission. These are the kinds of things a clerk might file without alarm, because the clerk's job is to process, not to interrogate. But for the person being excluded, Margaret Carnegie Miller, timing is everything. If a consent appears late, it suggests the consent was not driving the process, it was following it. And if consent follows the process, consent is no longer consent. It is documentation of compliance created after the path is already chosen. Another residue is valuation that doesn't align with prior framing, not necessarily a dramatic undervaluation or overvaluation. Those would invite scrutiny, but an incoherence, a number that sits oddly against earlier inventories, a figure that appears rounded in a way that suggests estimation rather than accounting, a reference to property or items that feels detached from previous descriptions. In a legacy estate, valuation is not only about tax or bookkeeping, it is about narrative control. The value assigned to the property and its contents can justify why a particular structure of governance must continue, why certain materials must be protected, why access must be restricted for preservation. A number that shifts can be used to support a shift in control. When the number doesn't align, it signals that the supporting story may have been rebuilt. And then there is the signature, the most human mark in an administrative world. The signature that appears standardized, like it was obtained through a template rather than through comprehension. The signature that sits on a consent form that reads like it was designed to remove standing, not to invite participation. The signature that in its placement suggests it was the final piece added to make the package look complete. A file will often contain language that makes these maneuvers sound harmless. Nunc pro tunc, words that sound like Latin precision but function like retroactive authority. The court, or the filer, treats something as effective as of an earlier date, even though the documentation is being processed later. On the surface, it is a tool for correcting clerical issues. In practice, it can also be used to close gaps that would otherwise expose how the process actually unfolded. It is the administrative equivalent of smoothing a seam after the garment has already been worn. This is not an accusation. It is an observation about the architecture of silence. A system that depends on looking clean after it has contained someone will naturally develop tools for cleanliness, corrected, supplemental, amended. These terms do not announce wrongdoing, they announce that the record is being managed, and a managed record is precisely what an excluded heir cannot safely challenge, because the challenge is always framed as pedantic. You're focusing on technicalities. But technicalities are where the power lives. In a trust case, the technicality is not decoration. It is the lock. The action of power here is the correction itself, the decision to treat the discrepancy not as a reason to reopen discussion, but as a reason to realign the file. Something is corrected. Something is made to fit. Something is attached to complete the narrative of closure. The consequence is immediate. The heir's remaining leverage weakens further because once a correction is filed and accepted, the system can claim the record is now consistent. Any later objection becomes easier to dismiss. It was corrected. It was clarified. It has been addressed. The burden shifts again, away from the administrators and onto the person asking why it needed addressing after finality. And that is the problem for Margaret Carnegie Miller. She is not being harmed by a single omission anymore. She is being harmed by a continuous process that can repair itself faster than she can challenge it. Her status has already been reduced. Her access has already been restricted. The annexes have already been sealed. By August, even the seams are being tended quietly to ensure the file remains smooth enough that outsiders won't notice the shape of exclusion. The misalignment also tells you something about who still had hands on the wheel. If a correction or supplemental schedule appears, someone had the authority to introduce it. Someone had the ability to request processing. Someone had access to the file after final. This is the opposite of closure. It is continuing governance by administrative touch. And continuing touch means continuing power. It also reframes the earlier disappearance. If names vanish from internal circulation in July and a corrective detail appears in August, then the sequence is not random. It suggests a controlled transition. Remove the person from the circuit, then tighten the circuit's paperwork so that the removal cannot be easily argued against later. The order matters. First you reduce visibility, then you stabilize the record. Only after that do you allow the legacy to resume its public calm. When a signature appears too late, is that carelessness or architecture of silence? August 1957 is where the mystery reignites because the discrepancy makes one thing impossible to believe: that everything was simply clean and settled. Clean systems do not need late seams. Clean closures do not require retroactive alignment. A final outcome does not usually generate supplemental schedules unless the outcome needed support it did not originally have. And notice what this does to the moral and frame. The story is no longer an heir lost a dispute. It becomes an heir was managed out of meaningful participation, and the record was maintained afterward to keep that management from becoming visible. That is not an error. That is method. Errors are admitted, methods are preserved. The last image of this block is concrete because the contradiction is concrete. An August 12, 1957 stamp on a one-page supplemental schedule, a notary seal that sits slightly out of sequence with the main feelings, and a standardized consent form where the signature line looks complete, while the calendar says it arrived after the story was supposed to be over. Once you see the August 1957 misalignment, the next question is no longer, was the file messy? The next question becomes, what would it have cost them if it had not been kept smooth? Because in 1957 and 1958, exposure was not a philosophical threat. It was an operational threat to a whole ecosystem that depended on the Carnegie name, reading as permanent, moral, and orderly. This is what the record never says out loud, but what the record is built to prevent. If the mechanics of the estate's containment of Margaret Carnegie Miller had surfaced in ordinary public language, it would not have stayed in surrogate's court. It would have spread into newspapers, into boards, into donor conversations, into the quiet social networks that decide which institutions are trusted and which are merely tolerated. Start with the press, because the press would not have needed technical mastery to understand the moral contradiction. A reporter does not need to explain nunc pro tunc to write a headline that lands. The story would have been framed in simple terms: a celebrated philanthropic legacy and a living heir reduced, classified, and managed out of meaningful participation under court authority. The language would have written itself. Legacy hypocrisy, philanthropy versus family, court-sanctioned erasure, mansion protected, heir humiliated. The public does not have patience for trust mechanics, but it has an instinct for institutional cruelty when it is legible. And once it becomes legible, the story becomes portable. It moves from a private governance dispute to a public moral question. How can a system declare itself correct while degrading the person it names? How can a court ratify a structure that treats a living heir as a procedural inconvenience? Those are questions Americans in the late 1950s were already learning to ask about other institutions. They did not use the same language, but the underlying tension, procedure versus dignity, was alive in the culture. If this case had entered that atmosphere, it could have been read not as a family squabble, but as a symptom of how wealth protects itself. Then come the alliances that would have felt the first real shock: boards, donors, cultural networks. In legacy institutions, reputation is not decoration. It is a resource. Donors give because the institution feels clean. Boards recruit because the institution feels stable. Partnerships form because the institution feels untouchable. A public dispute that implies trustees used procedure to erase or diminish an heir would have threatened that resource. And it would not have threatened it in abstract terms. It would have threatened it in meetings, in letters, in private conversations where people decide whether to attach themselves to a name. The Carnegie name, like any philanthropic brand, functions as a promise. The wealth was converted into public good, responsibly and honorably. If a credible press narrative suggested that the same wealth was being used under court cover to reduce the heir into irrelevance, the promise becomes complicated. Complications are corrosive. They do not have to destroy an institution to weaken it. They only have to make people hesitate. Hesitation is what these systems are designed to prevent. That is why the legal posture must be final. That is why the language must be technical. Technical language narrows who can speak with authority. It keeps the debate inside a professional class, trustees, counsel, clerks, rather than letting it expand into a public argument about dignity. There is also the market layer, which in legacy cases is not only about money, it is about symbolic value. The mansion is valuable as real property, yes, but it is even more valuable as a vessel for the Carnegie aura. Collections, archives, curated narratives, these are assets in a cultural economy. Their value depends on perceived legitimacy. If legitimacy is questioned, the asset does not disappear, but its social capital weakens. Visitors ask different questions. Donors give with caveats. Boards worry about scrutiny. Institutions tighten their narratives. The property becomes less of a monument and more of a site that requires explanation. That is why the record prefers the opposite: a monument that does not require explanation. A building that can be shown without footnotes. An archive that can be curated without argument. A legacy that can be presented as stewardship rather than contested governance. Exposure would also have created political and social implications that the system in 1957 did not want anywhere near a philanthropic brand. Trusts and fiduciary power were already an uneasy subject in American life. The idea that private wealth could be locked into structures that outlast the people involved, governed by trustees who could claim duty while exercising control. If this case had become public in moral language, it could have invited the wrong kind of conversation about trustees' power, about courts validating administrative containment, about heirs treated as technicalities, about justice as procedure rather than fairness. That is the kind of conversation that does not stay polite. It invites reform talk. It invites investigative reporting beyond one case. It invites legislators and commentators to Treat trust governance not as neutral expertise, but as a mechanism that can produce humiliation while remaining lawful. The system does not fear that because it would immediately collapse. It fears that because it would be forced into sunlight, where its clean words start sounding like excuses. Now add one more layer, the internal risk. Even if the outside world never found out, exposure within elite networks could have been enough. These systems are held together by coordinated restraint. Council assume discretion. Trustees assume loyalty. Institutional partners assume stability. The moment one participant breaks the posture, by leaking, by refusing to sign, by demanding public explanations, the file stops being a controlled object and becomes a contested object. And contested objects behave differently. They generate paper, they generate statements, they generate trails. That is why the august inconsistency matters so much. It is a sign of continued handling, of record maintenance. After final, which suggests someone was actively managing risk, you do not smooth seams unless you worry someone might look. You do not attach supplemental schedules unless you fear gaps. You do not rely on retroactive phrasing unless sequence itself is dangerous. The action of power in this block is not hypothetical. It is the preference for technical closure over public narration, choosing to end the matter in a language that cannot easily be translated into outrage, choosing procedure as insulation, choosing finality as a shield. That choice protects reputations and institutions. The consequence is equally real. The person harmed is left without a public forum that would treat the harm as moral rather than technical. Margaret Carnegie Miller is not simply outmaneuvered. She is denied the kind of visibility that could have made the system answerable. That is why the system could afford to be cold. It did not need to persuade the public. It only needed to prevent the public from having a story. A story is what creates pressure. A docket entry does not create pressure. A sealed annex does not create pressure. A corrected schedule does not create pressure. Together, they create a silence that looks like order. And in 1957-1958, order was the currency that kept philanthropic brands intact. If the story had reached the press, it would have threatened that currency. If it had reached boards and donors, it would have threatened the networks that convert private wealth into public legitimacy. If it had reached political discourse, it would have threatened the comfort with which trustees claim authority without scrutiny. Too many layers would have been forced to explain themselves at once. So, the system did what systems do when they are built to survive. It kept the dispute inside technical language, and it treated closure as an administrative virtue. It made the harm difficult to quote. It made the method look like maintenance. It ensured that anyone who tried to translate the injustice into ordinary speech would sound, to outsiders, like they were misunderstanding how proper governance works. The last image of this block is not a headline, because the headline never ran. It is a newsroom wastebasket that stayed empty, a folded draft story that was never written, while in a private boardroom calendar for early 1958, the Carnegie name remains scheduled as an untroubled symbol of civic virtue, untouched by the file that made it possible. By 1958, the file no longer needed to defend itself. It only needed to keep functioning. That is how silence becomes routine, not by one dramatic act of suppression, but by a sequence of ordinary procedures that make access feel conditional and conflict feel improper. This is the phase the public never sees because it does not look like scandal. It looks like management. It looks like a building being cared for, a legacy being preserved, an archive being protected. And because those words carry moral weight, they can be used to anesthetize what is actually happening, the conversion of an extraordinary dispute into an administrative normal. The vocabulary is the first instrument. Once an institution begins to describe exclusion as restriction, it stops sounding like exclusion. Restriction sounds prudent, maintenance sounds necessary, preservation sounds virtuous, administrative efficiency sounds like common sense. None of these words admit a victim. None of these words admit a power. Struggle. And yet in practice they produce the same outcome year after year. The heir is no longer treated as someone whose participation is assumed, but as someone who must request permission to approach what should have been hers to know. In this period, 1958 through 1962, governance hardens into policy. It is no longer a strategy carried by a few people with a particular goal. It becomes the way the place operates. That is the most durable form of power, when the method outlives the moment that created it. A visitor sees the mansion as stable. The file sees it as controlled. The difference is not philosophical, it is procedural. The procedures are simple, and that simplicity is what makes them effective. Access is placed behind credential, not always a formal badge. Sometimes it is merely an internal understanding of who belongs. The archive room becomes a place that requires authorization. Authorization requires a request. A request requires a form requires processing. Processing requires time. Time requires patience. Patience is what the excluded party eventually runs out of. When the heir, Margaret Carnegie Miller, wants to see something, she is not told no in a way that creates an argument. She is told, not yet, not in that format. Not without counsel, not without approval, not without a specific citation, not without an appointment, not without supervision. Each condition sounds reasonable in isolation. Together they are a wall, built from politeness. That is the method, a wall that never calls itself a wall. The institution also learns to standardize its own memory. By 1959, reports are written in a tone that assumes the dispute is over. Meeting minutes reflect ongoing administration rather than contested governance. Policies refer to legacy materials instead of family papers. Each phrasing change is small, but the accumulation matters. Language is how institutions decide what exists. If conflict is not named, it becomes harder to reintroduce. If an heir's participation is not assumed, it becomes easier to treat her absence as natural. And naturalness is the goal, because once exclusion feels natural, it stops needing justification. This is where the earlier acts, sealing annexes, collecting consents, reclassifying interests, do their long-term work. They give the institution a procedural basis for gatekeeping. If a question arises, the answer is policy. If access is requested, the response is procedure. If outrage is attempted, it is reframed as misunderstanding. The heir is no longer confronting a person. She is confronting a system that can always claim it is merely following responsible governance. The action of power in this block is not a single seal or a single denial. It is the ongoing restriction of access by credential and routine. Restricted hours, restricted rooms, restricted copying, restricted circulation. A system where documents are available for inspection only under conditions that prevent real comparison. A system where key decisions are preserved in internal correspondence that is not part of the ordinary record offered to outsiders. A system where the public-facing narrative is stable and the contested layers remain buried under administrative calm. The consequence is just as real as any courtroom loss: institutional fatigue. The heir loses not because she is disproven, but because the institution can outlast her attention span. Every request becomes work. Every Follow-up becomes a negotiation. Every attempt to push harder carries reputational risk. The institution can always frame her as disruptive to preservation, disruptive to stewardship, disruptive to public trust. This is how a victim is defeated without the satisfaction of a visible defeat. The system does not crush her in a headline, it drains her in process. And while this happens, the public remains undisturbed. That is not an accident, it is the product. The public sees a preserved mansion, a philanthropic name, an unbroken line of responsible governance. The public does not see the request forms. The public does not see the gatekeeping. The public does not see the polite refusals that accumulate into removal. By 1960, the archive begins to behave like a controlled resource rather than a family inheritance. Access is treated as a privilege granted for proper purposes, not as a right attached to blood and legacy. The idea of proper purposes is elastic. It can include scholarship that supports the institution's narrative. It can exclude inquiry that would reopen governance questions. It can favor the neutral, the celebratory, the architectural. It can delay the personal, the contested, the humiliating. If someone inside the institution wants to keep the story clean, this is the dream framework, a set of policies that look like care and function like control. And because those policies are written in the language of virtue, they are hard to challenge without sounding unreasonable. Why are you asking for unrestricted access? Why do you need that annex? Why are you reopening old matters? Each question shifts the burden away from the institution and onto the person who wants to see. The institution becomes the guardian of responsibility. The heir becomes the risk. This is the moment where silence becomes governance. Not secrecy as a dramatic act, but secrecy as workflow. The extraordinary becomes routine because the routine has been designed to absorb it. The case is not defeated. It is filed, it is labeled, it is placed on a shelf with a policy attached to it. That is what institutionalization means. The conflict is converted into an administrative object, and administrative objects do not demand moral reckoning. They demand compliance. What survives from 1958 to 1962 is not a scandal, not a public dispute, not a courtroom drama. What survives is a method of keeping the record clean enough for the public to never form a story. That is why the Carnegie name remains stable, why the building remains untarnished, why the legacy continues without footnotes. Silence is not an absence. It is a maintained condition. The last image of this block is not sensational. It is a policy binder. A typed sheet dated October 2nd, 1961, labeled Archive Access Procedures, a checklist for approvals, a note that reads Restricted Materials, Staff Only, and a key that never changes hands, while the heir's questions, unanswered, become the kind of paperwork no one feels obligated to complete. By the time you reach 1976, the case is no longer an active file in the way it was in 1957. It has been processed, normalized, and folded into the kind of institutional calm that makes a legacy feel inevitable. And then something happens that completes what the decree began. The mansion is consecrated into public narrative in a way that does not leave room for the conflict that made that narrative safe. This is the moment when an estate becomes a monument. In 1976, the building is no longer merely a private vessel carrying a famous name. It is treated as a public asset, officially framed and publicly intelligible. A formal transfer, a dedication, a museum logic, an institutional act that fixes the mansion's meaning in the public imagination. The action is concrete. Authority over the property's story is reassigned from family gravity to institutional custody. The consequence is also concrete. Once the institution is the custodian, the public inherits a clean version of history by default, and the living heir inherits silence as an outcome that can no longer be argued with ordinary tools. That is what this bridge to the present is for. It shows the final shape of the method. The 1957 containment was not only about winning a moment, it was about protecting the conditions that would allow the mansion to become a stable public symbol. You cannot build a stable symbol on top of visible governance humiliation, not if the symbol is meant to represent virtue. So the conflict had to be reduced, categorized, managed, and then quietly excluded from what the public would later be invited to remember. The legacy that remained is visually perfect. The mansion stands intact. The architecture becomes the headline. The benefactor becomes the moral. The story becomes a guided experience. Rooms, objects, portraits, philanthropy, the great man aura that American civic culture knows how to honor. A visitor can walk through permanence without feeling the seams, but the clean surface is exactly where the injustice lives, because a surface is not neutral. A surface is curated. The official narrative preserved in an institutional setting has a particular shape. It favors continuity over conflict. It favors architecture over governance. It favors donation and civic improvement over private control. It treats the benefactor's intentions as a settled good, and it treats the afterlife of the fortune as mere stewardship, an extension of virtue rather than an arena of power. And in that framing, there is no place for 1957, or rather, there is a place for it only as an administrative detail that no visitor would ever be encouraged to ask about. Because 1957 is the year that breaks the moral simplicity of the legacy. It is the year that reveals what the public story cannot accommodate, that a mansion can be protected by law in a way that humiliates the person closest to it, and that humiliation can be processed as proper governance. This is the part that remains unexplained. Why does March 14th, 1957 exist in the chain at all? Why does April 3rd, 1957 appear as a trace of continuing procedure after final? Why does August 1957 contain a seam that suggests retroactive alignment? Why does July 1957 read like a removal from circulation? These are not questions a museum label answers, because museum labels do not explain power struggles inside governance. Museum labels explain meaning, and meaning is easiest when it is clean. The contradiction is historical and structural. Institutions exist to guard history, but they also choose what history is. They decide which documents become the public-facing proof of a narrative and which documents remain dormant in restricted folders. They decide which rooms tell a story and which rooms remain closed. They decide which names are said aloud and which names are treated as background. They decide what visitors are guided toward and what visitors are never shown the route to. That choice is not always malicious. It does not need to be. It only needs to follow incentives. A museum is built on trust. A philanthropic legacy is built on moral comfort. A landmark is built on celebration. Conflict threatens all three, so the conflict is not argued with. It is excluded by design. This is where the earlier vocabulary, preservation, maintenance, administrative efficiency, reveals its final purpose. Those words do not end when the file ends. They survive into the institution's posture. They become the terms used to justify restricted access, curated interpretation, and the absence of uncomfortable questions. Preservation becomes not only preservation of objects, but preservation of narrative stability. Meanwhile, the human cost remains private, which is exactly how the system prefers it. A monument does not display the person it diminished. A monument does not include a plaque explaining the administrative humiliation that made the monument safe. A Monument does not say, "This continuity required exclusion." It says, "This continuity is heritage," so the public inherits the clean story. They inherit a building and a benefactor and a civic lesson. They inherit the impression that wealth became virtue and stayed virtue. They inherit the idea that the legacy's transition was orderly because nothing about it looks contested. They do not inherit the record of a living heir reduced to secondary, then managed through procedure, then removed from circulation, then overwritten by routine, then eclipsed by institutional consecration. And the victim inherits something else, the knowledge that even when you're attached to a famous name, you can be treated as an administrative inconvenience. The knowledge that the record can acknowledge you and still deny you. The knowledge that final does not always mean truth, it means closure. The knowledge that a building can be preserved with more tenderness than a person. The action of power. Here is the reassignment of custodianship over the meaning of the place. Once the institution holds the keys, it holds the interpretive authority. And interpretive authority is the most durable kind of control because it shapes what future generations believe happened. It does not simply keep the building intact, it keeps the public's memory aligned. The consequence is the last stage of erasure, not erasure of bloodline, but erasure of conflict. The heir is not defeated again. She is made. Unnecessary to the story. Her questions become irrelevant to the public version of the legacy. Her humiliation becomes a private fact without a public address. And yet, the documents survive in fragments, a docket line, a supplemental schedule, a restricted annex, a policy binder, the artifacts of a method that outlived the moment that required it. What we are left with in 1976 is not simply a mansion turned into a monument. We are left with a monument that asks us to trust its cleanliness without asking how the cleanliness was achieved. The public story is stable. The private story is sealed. The institution is respected. The record is curated. The last image of this block is concrete and unresolved. A 1976 dedication program laid on a polished table in the Carnegie Mansion. Visitors moving through rooms under soft lighting, and, behind a staff-only door marked "Restricted," a file box with a 1957 court reference. Still closed, still quiet, still waiting for someone to notice that. A clean legacy can be the final product of an unspoken humiliation. In January 1981, enough time had passed for the official story to feel settled, polished by repetition, insulated by ceremony, and protected by the quiet confidence of institutions that know most people will never ask what was filed, what was sealed, and what was quietly reclassified as resolved. The mansion stood, the legacy stood, and the public memory stood with them, as if permanence were proof. But power that lasts is rarely built on wealth alone. It is built on custody. Custody of language, custody of access, custody of the record that determines what can be said without being dismissed. When an estate is defended, it is not always defended in debate. It is defended in the administrative space where outcomes are made to look like procedure, and where procedure is granted the dignity of inevitability. That is the institutional moral this case leaves behind. In 1957, nothing needed to be loud to be decisive. A decree could be framed as closure, an accounting could be framed as stewardship, a restriction could be framed as preservation, a sealed annex could be framed as prudence. And then, year after year, the vocabulary did what force does without appearing to force. It narrowed who could speak, what could be known, and which questions would be treated as legitimate. This is why the elite seldom needs to win in the dramatic sense. It does not require a spectacle. It requires a file that outlives discomfort. It requires a corridor of policies that can absorb outrage until outrage collapses into fatigue. It requires a record that can say, with a straight face, that nothing improper occurred, because the harm was not illegal. It was administrative. It was conducted in clean terms. It was carried out in daylight that only clerks and counsel could see. The law remained upright. The mansion remained immaculate. The institutions remained confident. And somewhere inside that order, justice did not fall in the way a courtroom imagines justice falling. It was not shattered. It was not disproven. It was reclassified, moved into categories that made it easier to ignore, filed into language that made it harder to quote, and sealed behind doors that do not open unless someone insists on returning with the right questions and the patience to endure the delays. A mansion is never merely a mansion. It is an outcome. It is the visible surface of invisible decisions, of who was permitted to remain central, and who was quietly moved to the margins so the building could continue to stand as if it had always stood by destiny alone. And that is why these halls matter, not because they contain ghosts in the theatrical sense, but because they contain records, quiet instruments of power that can outlast the people they diminished. The most enduring victories are not always written in headlines. They are written in administrative language, preserved in folders no one circulates, protected by policies that sound like care. If you want to keep walking with us through these corridors of sealed paper and controlled memory, subscribe to Beyond the Golden Halls, so that you're here when the next sealed door finally opens. Leave your thoughts below. Every perspective helps illuminate what history tried to bury. And if this story resonated with you, let us know. It tells the algorithm these forgotten halls are worth exploring again. Because if you are willing to step deeper into the shadows, the next chamber awaits, and it too will look serene from the outside. Tonight, the lights in the mansion remain soft. The corridors remain quiet. A file is returned to its box, the string tied again, the label facing outward like a statement of permanence. And somewhere behind the calm, a truth survives, not destroyed, not defeated, only waiting. Some secrets survive only because those who feared them left no one to tell the truth.